Appeals, First Appellate District of Ohio, with the Honorable Marital presiding, is now in session. Please be seated.
Good morning, everybody. Welcome to the First District Court of Appeals. We have two cases on the docket to be argued today. I'm going to call each case, and if the attorneys could introduce yourself and indicate your readiness to proceed. The first case is Carter versus Carter.
Good morning, Attorney Patricia Voss for Mr. Carter, the appellee.
Okay.
Just for trial, on behalf of the appellant.
Okay.
We're prepared.
Okay, great. And the next case is State versus Johnson.
For the state.
Okay.
Your Honor, Judge O'Reilly on behalf of the appellant.
Okay, great. So if the attorneys on Carter versus Carter could go ahead and come forward. And Mr. Collinger, would you like any time for rebuttal?
Yes, let's reserve 3 minutes.
3 minutes? Okay. I'll keep your time with the light system, and you may proceed when you're ready.
Thank you very much. Good morning, Christopher Trollinger on behalf of the appellant, Trinette Carter. This is obviously a case that comes out of the Hamilton County Domestic Relations Court on behalf of a divorce. There was both magistrate's decision objections filed by the appellee as it relates to that magistrate's decision, then ultimately a judgment entry on those objections and divorce decree. As to the first assignment of error, this relates to a granting by the trial court judge of a motion in limine in the order. For review of the transcript of the proceedings, however, indicates that that motion in limine, albeit was denied by the magistrate at the time of the admission of the evidence, the exhibits were admitted in the evidence without objection by the appellee and counsel. As such, the issue was waived and should have not been granted before the trial court judge.
I thought they did object.
Not at the admission of the exhibits. There was the initial motion in limine, and then the magistrate, at the close of the testimony, asked for the evidence. It was offered by the appellant, and ultimately it was admitted by the magistrate with no objection at that time, at the time of the admission. So therefore, it would have been waived at the time of trial.
So you're saying at the very end, when the parties got together and they were going over which exhibits come in, you're saying that that's the time when the exhibit was admitted?
That's correct.
Okay, because I thought it was admitted earlier in the proceedings, and they did object.
Correct. No, it was not. It was offered. It was obviously offered, identified in the course of testimony, but then ultimately the magistrate waited until the close of all the testimony over the exhibits, and it was offered for admission at that point in time. The magistrate accepted it at that point in time, asked the parties if there was any objection. The answer was no.
Okay, so despite the fact that they objected on 2 prior occasions, you're saying this final objection is what caused them to waive?
Correct, because it's as a motion in limine, it is obviously a preliminary order. It was ultimately denied at that point in time, but ultimately, in order to preserve that issue, you need to re-raise the objection at the time that the court is admitting the exhibits into evidence. As it relates to the second assignment of error, the trial court erred in assigning the debt associated in this matter solely to that of the appellant. There is no equitability finding in this particular matter. It seems that there was basically a punishment as it relates to a late disclosure. The evidence, however, before the court was that the debt ultimately was known to the appellee at the time. Especially the Navy federal debt, and he identified in his testimony he knew it was maxed out. There's no testimony that it's not marital debt, and it's, as this court earlier last year had indicated, it certainly needs to be allocated, and it would be inequitable given the circumstances and the totality of the debt and the assets and the total allocation to allocate over $32,000 of marital debt solely to the appellant.
How many credit cards are we talking about here?
On this particular one, there were, I believe, 3 or 4 credit cards that were identified The Navy Federal is the largest one with a debt in excess of over $24,000. There's the Capital One debt of $2366.24, the PayPal credit card debt of $2687.64, and a Discover credit card debt of $3808. So,
and you're saying that that this was all known. So was the trial court's conclusion that there was a violation of the mandatory disclosure orders, was that wrong?
Yes, in the sense that it was ultimately, albeit form over substance in the matter, it was not necessarily on the affidavit, but it was disclosed. It was known by the.
So where was it disclosed?
It was disclosed in the fact that the appellee already knew about the debt. He knew that there was a Navy Federal Court.
Or just the Navy?
The Navy is what shows up in the testimony. He identified, though, that he knew that the parties had debt, and I think he identified it was this Discover card was the other one he knew about. But it is the Navy Federal that obviously is the bulk of the debt, and the one which it's irrefutable that he testified he knew about that debt all the way back to 2013. Additionally, there was discovery conducted, subpoenaed responses returned, and the appellee had all of the statements as it related to that Navy Federal card debt in his hand.
He had all of the Navy Federal statements
That's
and
correct.
discovery?
Yes.
Okay.
But wasn't that late discovery?
There was
it
ongoing,
ordered?
correct. I
It
mean,
was
it was
ordered
late
to be-
discovery in the course of the overall proceedings,
Mhm.
as both sides had continued to conduct discovery. If you look through the day-to-day testimony and transcript before the magistrate, there was discovery that was ongoing basically throughout the entire trial.
Wasn't it disclosed 2 years after the proceeding was filed?
The Navy Federal, no, but it was obviously because the appellee knew about that debt and testified to that in that regard.
But the trial, or the magistrate specifically required, after they took a break, after the first day of trial, when this debt was revealed, required the wife to turn over or make the disclosures before the trial resumed again, and that was never done.
Ultimately, I believe the transcript would identify that there were statements provided to the appellee during that period of time. In addition, the subpoena responses came in, and the appellee actually provided that to the appellant. So it actually was conducted at that point in time as it relates to Navy Federal.
So you're saying that prior to when the trial picked up on the second day, wife had complied with the magistrate's order to turn
Correct.
over, to make the disclosures?
Yes, to the best of her ability, and then additionally, the superseding subpoena responses came in.
Okay.
And this is all in relation to the fact that there was additionally $153,000 of student loan debt, both for the benefit of Miss Carter as well as their child. And she did not object to being allocated for that student loan debt, but clearly the testimony before the magistrate and at trial was that was a benefit to the marriage, that he encouraged her to do that, wanted her to better her position, wanted to better it for the family. And she did that all the way back into the early teens. So it wasn't something that she did in 2020, right before the end of the marriage, but it was conducted during the marriage and was a benefit to the parties in the marriage as far as her education. The Kia car, the trial court erred as it relates to that vehicle. There's a definition of separate property, and simply put, the Kia does not meet any definitions of separate property as identified in 3105-171A6. It was a marital asset purchased during the marriage, insured by the parties, and ultimately totaled with a check issued to the appellee. The testimony that it was used for a child does not change the identity of marital property for purposes of the division, and that should have been taken into account. As it relates to the spousal support, the trial court erred in ordering $2,085.66 per month in spousal support.
Just on the Kia,
Sure.
was that the check was issued to husband, but then did he essentially turn that check over or pay it to the child for their vehicle?
Presumably, that is what had occurred, unbeknownst, obviously, to the appellant at the time. That is what I believe I gleaned from the transcript.
Right.
That's uncontroverted testimony from husband, right?
Yeah, correct.
He did not receive any of that money.
He received it, but he turned around
turned
and
it over.
then gave it to the
And the
child.
child made all the payments on the car as well,
To our knowledge.
and
yes.
drove the car.
Yes.
So he didn't have it was simply titled in his name, and he had no benefit from the car.
It was titled in his name. I mean, obviously, the benefit was that it was driven by the child who was a minor at the time it was obtained.
I thought she was an adult.
I don't believe at the time that the car was obtained. I believe at the time that it was totaled, she was.
Okay.
As it relates to, again, the spousal support, the trial court erred in minimizing, the magistrate was correct in providing that the overall debt allocation that the wife had taken and the overall property distribution as determined by the magistrate lessened the wife's obligation on the spousal support, which would be a correct determination, by the trial court issuing such an unequal and therefore inequitable division of the debt and overall assets. And then on top of that, without much explanation really at all, as it relates to how the trial court came to that specific amount of spousal support, that is not shown on the record at all. So for this court to be able to review that amount, the trial court failed to provide.
So there's nowhere in the
justification.
record that shows the derivation of the $2,085.
Correct.
Okay.
It's simply a dearth.
Well, so there's no, you answered the question, but there's no worksheet or anything because it's such an odd number of $2,085.66. There must have been some calculation the judge did.
You would think.
You don't know what it is.
Correct. And it would left for this court to simply guess as to what that might be. That being the case, looking to the evidence before the court, as well as the division of the property distribution, allocation of debt, that would certainly be an inequitable number for such a jump from what the magistrate heard at the trial, as well as not only did the trial court judge increase the debt obligation for the appellant, but then further basically quadrupled the spousal support amount on top of that. So not only did the distribution that should have been considered prior to ordering spousal support, which is the order in which they would go, would identify.
And you are at your time.
Thank you.
Can I just ask a quick question? On your final assignment of error, I was a little confused on that. To
Sure.
provide document, it just seems to me like there's no contempt finding or order by the court saying that the wife didn't comply. I don't know what we're supposed to do with this assignment of error.
So as it relates to this assignment of error, by the trial court's decision, and the argument here is simply the trial court gave, the tuition was ongoing through the proceedings even during the issuance of the divorce decree. So the trial court essentially ordered by June 1st, wife to turn these over in order to be reimbursed. So this created an impossibility for wife to comply with the divorce decree because this was issued May 26th of 2023. A superseding holiday occurred on that Monday. By the time wife would even get notice of this decree, she's already unable to seek reimbursement of that tuition.
What are we supposed to do with this?
Well, we would ask that you would reverse and this decision remanded for the trial court to issue an order that gives wife the opportunity to meaningfully respond, to provide those receipts, because it was, again, an impossibility in the divorce decree given the timing. I said June 1st, it was May 26th.
But she hasn't been found in contempt or anything.
It's because she paid the
Okay.
tuition.
Okay.
And then she's seeking in the court order that husband would reimburse her for that tuition,
Okay.
presuming she could provide him with those receipts.
Okay.
Because she could not provide him with those receipts, she could not get the reimbursement.
I gotcha.
And so we would ask that this be reversed and remanded for the court to correct that so she can provide those receipts in a meaningful way, because it would be an abuse of discretion with such short turnaround.
Thank you. Ms. Potts?
Good morning, Your Honors. On that last issue, if I may, that documentation regarding the expenses she paid for the child's final school year tuition, she was put on notice that she was going to need, first off, as a practical matter, if you want to be reimbursed for anything, you're going to need to show receipts for what you paid. So this is not an extraordinary requirement for her to have to document what she paid, and she certainly wanted to be reimbursed a portion of those expenses. We had objected to the 50-50 allocation, and that objection was before the judge. The judge, in rendering the decision on the objections, she sustained the 50-50 allocation of expenses for the child's final school year tuition. And at that time, and that was entered, the entry on objections was February of 23, and said that wife had to produce that by the beginning of May. And so because there was a delay, because there was a prior filing of an appeal in this case, so the wife was on notice in February to accumulate the receipts, produce them to husband. She didn't do that during any of that time. And then when the judge did put on the entry, gave her until June 1st. So she really had from February of 23 to June 1st to get the documentation together, which corroborated what she paid for tuition. And the child had graduated on the 28th, and presumably all the bills would have been paid by then, May 28th, excuse me. I wasn't clear about that. So I think that, I don't know why she needed more time or why that's even an issue. That just seems very odd.
So because she didn't do it, husband doesn't have to reimburse?
I don't think so, but this has been the chronic problem throughout. The wife doesn't do what she's supposed to do, as any litigant otherwise does.
Well, let me ask you this. Can you, I'm struggling with the spousal support issue. Mm-hmm. Can you explain the derivation of that figure?
The dollar figure? No, I can't specifically. It comes out to about $25,000 a year.
Right.
And when I look at the math, the wife's most recent year at trial of gross income was $120,000, and husband had less than $10,000. Although the court imputed $40,000 by averaging the prior year's income and unemployment to come up with the child support amount and put $40,000 in there, I think the judge figured, well, if we do he's got next to nothing, she's got $120,000. I think the court just came up with a 20%, I believe, is what it comes out to figure.
Well, right, but like how are we supposed to evaluate that, even under a discretionary standard, if we don't understand how the court got there?
Well, I think if you look at how the court got there the same way the magistrate got there, by looking at the factors.
Well, but the magistrate only came up with $500.
Which was an absolute abuse of discretion. You have a 16-year marriage.
All right, okay. So I understand that. I understand, like, you say 500 is way too low, they say 2,000 is way too high. But, like, what we're trying to do is figure out, did the trial court appropriately evaluate these factors and come up with a defensible number? And my question is, how do we know that for this $2,000 figure?
Well, again, what I would do is look at what the court said, because we don't have a worksheet for spousal support like we do with child support. And perhaps the judge used the sort of the de facto default Warren County calculation to come up with this. But the reality is she looked at the factors that the evidence presented: the duration of the marriage, the disparity in the income, the health of the parties, their age. And I think when you look at all of those things, and the fact that the husband was supportive of the wife during the marriage, which allowed and laid the foundation for her to acquire her degree, that she was going to be leaving the marriage with a degree where the history showed her income was only increasing thereafter, that it was not an unreasonable amount, $25,000 a year for 5 years. And especially when the court even factored in, the court maintained jurisdiction to modify that. So if the party's circumstances changed, if the husband was able to get back to work and earn more money, or if all of a sudden wife had to pay more than the $50 a month on that student loan, then the court could adjust that given the then circumstances of the party. And I don't think there's a requirement that the court has to give the actual calculation. I think the court abuses its discretion when it just comes, when it doesn't rely upon the factors that are enumerated in the statute. And I think the court did rely upon those and came up with the amount that the court felt was reasonable under the totality of the circumstances.
I thought the case law requires the court to indicate the basis and the reasoning.
I think she did indicate the basis and the reasoning. And again, if you look at the disparity in the income, you look at my client's inability to become employed at that time, and the allocation of debt, etc., I think it was a reasonable conclusion.
And do we understand why she went to 5 years versus the 3 years the magistrate found?
I would believe it's because it's customary, frankly, to be about 1/3 the length of the marriage. That's not an unusual duration.
Okay.
So,
But we don't really know what prompted her to increase it from 3 to 5 years.
no, other than she believed that the magistrate had just gotten it wrong. I mean, $500 a month for 3 years when you have a 16-year marriage, you have a disparity of income to the extent that you do, and you have one person who's only escalating in income and one person who has little to no income because of health problems. That was a pretty astounding amount that the magistrate ordered, I thought. I thought that was a real abuse of discretion and surprising.
Let me ask you this, Matt. You referred to, I think, Warren County just says, okay, 20%, that's what we're going to do. Everybody knows that. In Hamilton County, do the judges or do any of the judges in a domestic relations court show a calculation how they got to a certain number on spousal support?
Not that I've seen. Now, maybe I'm just not as familiar as everybody else, but I've not seen that. And in fact, the Warren County one, it's not just like a 20%, it's based on the years they're married, it's income and all that. But that's kind of been a de facto calculation that attorneys in the court, I think, often engage in just to give a direction as to what the support should be. But unfortunately, we don't have any more direction from the state as far as an actual calculation. But I think the reason we don't is because you want to leave it to the court, who hears the facts, who hears the testimony, to render the decision as to what's appropriate given the circumstances. Because once you do have a hard and fast calculation, then it doesn't take into account the nuances necessarily. So, I mean, that's just a little editorializing on my part, and I probably shouldn't have gone that far.
Well, but the challenge that we have is, like, say the same exact language was in here, but it said $500 rather than $2,000, and you just said that's outrageous. Like,
that's an abuse of discretion, I would say.
Right, but like,
how would I come to that?
How would we evaluate whether 500 is appropriate or 2,000 when all we see in this order is the court saying, like, you know, based on the factors in section whatever, it's not explaining the reasoning in a way that we can evaluate it and test it, and it would essentially insulate any order from appellate review.
I don't think it does, because I think when we're talking about something that's an abuse of discretion, it's something that's unreasonable that an ordinary person or the appellate court can look at and say, that's unreasonable. And I think if we were looking at $6,000 a year for 3 years, given the duration of the marriage, given the income of the parties, given their contribution to the marriage, I think a reasonable jurist, a reasonable person would say that's outrageously low. That's not appropriate. Just as I would think this court can look at what the court did. And the court said she reviewed what the magistrate did, and he spelled this out. It's not like she's just summarily saying, I looked at the statute. She's saying, I evaluated it the same way the magistrate did. And I include that in my brief there, what the magistrate did and the judge affirming that. And so I think we do have direction on what the court looked at and why she came out to that particular decision.
But we have this additional issue that the appellant brings up where the wife is saddled with all of the student loan debt that was acquired during the marriage. Apparently there was testimony that both parties wanted her to go back to school to make a better life for both of them. And now she has to pay all of this debt. I mean, couldn't that be something that the magistrate was taking into account in determining the spousal support?
Well, and I think the court thought that may have been the case, but the judge found that the magistrate looked too much at the end figure as opposed to what the actual out-of-pocket was. She's only paying $50 a month.
Well,
And so while it may,
but she's never going to pay it off at that rate.
well, I don't think it matters if you're paying it off at $50 a month, whether it's paid off or not. And of
Why
that,
wouldn't
only
that matter to get rid of debt that you have hanging over your head?
well, she could always pay more, but she hadn't established that she was paying anymore. So, I mean, the other thing about that is only $90,000 of that is her debt. The remainder is the daughter's debt that my client did not co-sign on or endorse. And I don't know if that was used for the child's graduate work or what, but my client did not sign on to that and wouldn't be saddled with that. So we're looking at that. The other thing you got to keep in mind with this is not only the low payment she has, but she's only 42. And she just acquired the bachelor's degree in 2014, I believe. And so the majority of her use of that is going to be the next 20, 30 years when she's working, and she's going to derive a substantial benefit from that.
But that's the whole problem with this, is that if the judge would have simply just laid it out and said, okay, here's how I got to this figure, this is what I'm looking at, instead of us trying to speculate.
But she does on that issue. She says that the magistrate put too much emphasis on the amount of it and not the reality of what the payment is. And she says specifically the payment's only $50. Should that payment increase, then that's an appropriate time to bring this back because the court retained jurisdiction over the amount and the duration. And so the court says, I'm being realistic here. If that does increase, that has an impact. But at this point in time, the reality is it's $50 a month.
Well, could wife, I mean, with that idea, could she decide, hey, I want to aggressively pay this loan off and say, I'm going to pay $1,000 a month to pay off this loan?
And trying in order to defeat my client's...
No, just to get her to start paying
well,
off
sure,
the
she could
debt.
do that, but she would still have the obligation to pay the spousal support.
Could she get it reduced at that point?
I don't think so. I don't think so.
So
I
she's
mean, I
locked.
think she
She's
should
locked in
probably
at
do
this
that.
$50. I mean, she can't make the decision to pay more.
She
off it.
certainly can, but she's going to have to become a bit more financially responsible, for lack of a better term. You know, I mean, if she has the ability, she was working full time, making $120,000 minimum, and then she started her own little side gig at a janitorial service and boasted about that on her advertisements on how well that was going. So she certainly has the ability to pay it off sooner and still not interfere with her obligation to pay the spousal support. But I think the judge very specifically addressed that and gave a lot of deference to the wife in the event those circumstances should change and she has to pay more. I think the other big thing, I presume my time is tick-tocking.
You have 2 minutes.
Okay, real quick, on that debt, I think the court has to realize that the wife was under an obligation when she filed the affidavit of income and expenses to identify all her debt. She was under that same obligation when she filed both of these sworn affidavits, the property statement to disclose that debt very early on in the litigation. She did not. She was under the mandatory order of the court to disclose.
So was this a sanction essentially?
Part of it's a sanction because I don't know if you want to call it a sanction or our inability to prepare, to argue against
Well,
it.
they said
Yeah,
that.
I thought you all knew about it.
Yeah.
But, okay, that's totally not true.
Okay.
Mr. Carter testified, I knew she had an account in 2013. He didn't know what the balance was at that point. And so she had all these obligations to disclose that. She has the statutory obligation to disclose her debt. We're scheduled for trial in January, and there's no mention of this. We've exchanged exhibits, we're ready to rock. And she decides she needs a different attorney. So she gets a new attorney, and this is continued until April 7th. It's not disclosed the first day of trial. It's disclosed the end of the second day of trial, which was May 31st. It was at that time that the magistrate entered an order, a scheduling order that said, you have until July 15th, I believe it was. Yeah, July 15th to provide 24 months of statements preceding the end of the termination. So we didn't have all that stuff then. On May 31st, we had the one statement showing the balance. And it is correct that I discovered that because I was trying to find where the money was. Because she's making all this money, and then I find the $15,000, and I don't know if you've read all this stuff, but there's a $15,000 IRS refund that wasn't disclosed. She also received a $30,000 small business loan that wasn't disclosed. That's me digging up all this stuff, but I don't have all this documentation. And she was supposed to provide that by July 15th, and she didn't provide it by the 15th.
So how do you address that they're saying when you were finally asked at the end, when they were admitting all of the exhibits, whether there was an objection? The answer was no.
I may not, and I probably should have renewed my motion in limine, and if I didn't, that's my error, but that's not fatal, because I filed an objection. The court said I would have granted that motion in limine. So I think that makes the fact that I didn't object moot, but it doesn't change our overall argument. Even if it was admitted, it should not have been allocated to my client. There was an additional $30,000 of debt which was disclosed, and the parties entered into stipulations to divide that. And in fact, the order was that my client had to use some of his money from one of the property proceeds to pay his portion of that. The same was not true for Ms. Carter. She could pay any of this debt at however she did. And so I think that's, the court acting fairly by allowing her as much time as she would need to take care of this debt. But I think, she was given umpteen times to disclose it, so she didn't. And how am I supposed to prepare? How am I supposed to even argue this? This case is going on for 2 years, and on the second day of trial, and then even after that, you're ordered to produce this documentation, and she doesn't do it.
And you're at your time now.
Okay. Thank you, Your Honor.
Thank you. Mr. Trollinger, you have 3 minutes.
Thank you very much. Yes, as it relates to the spousal support, essentially the problem here is Ms. Carter, the appellant, has been saddled with approximately $186,000 of additional debt that the appellee does not. And when allocating the property, I think the last point was, you look to the total amount. If you were to offset an asset with the debt, that's what we do on a balance sheet, but we don't look to what's the monthly payments on these credit cards. So you get $60,000 of debt because your payment's only $2,000, and you get $30,000 of debt because your payment is $2,000. Like, that's not what we do. That's not 3105171, and certainly the court should have taken that into account in the spousal support calculation. Coming up with a $25,000 or so number a year at $120,000 for a wife, they imputed husband. They identified his income at $40,000, $25,000 net of taxes. That's not even equal. That's saddling wife with more than 50% of the total income as far as spousal support, on top of approximately $200,000 of debt, and that's not equitable. And the court did not show their work on how they came up with that number or how that number would become equitable. And because it's certainly not equal. Looking to, as well, as far as the evidentiary issue, both of them, even had the magistrate granted the motion in limine, if at the time that the exhibits were going to be admitted or not admitted into evidence, one would still have to renew the objection even in a granted motion in limine, because the motion in limine granting is not final. That is not the end of it. You have to continue on making your objection. Even if you had a motion in limine prior to trial granted, you would have to continue on that path. Just like had the proponent of the evidence not proffered the exhibit, it would have been waived. So the issue here is again waived as it relates to the evidence that was presented before the court. And I think this court was correct in its question of whether or not that was a sanction. It seems to equivocate that the court essentially was sanctioning because there was no equitability in the finding of the marital debt. If there was no disclosure and there was debt out there, this court has previously stated that all debts and assets must be divided and distributed. That is the court's job. The equitability of that is looking to the total circumstance of the parties, the total debt picture, the total asset picture, and making an equitable division of that.
But not if the spouse willfully fails to disclose the debt, right?
I don't believe so. If there's businesses out there and you have a business that's not dealt with in divorce, and even if it's not disclosed, but it's known, that is still something that needs to be divided. Here, there was the Navy Federal, it was known, and it needed to be divided.
But you're saying it was known, like, I get that, but don't you have to tell the court if you want it to be divided?
And there was testimony, obviously, about that document, and then they brought it in as it relates to trial. So there was opportunity for cross-examination, opportunity to be dealt with as it relates to that and taken into account. And here, settling $186,000 of additional debt on top of equalizing that remaining debt is simply just an inequitable result given the circumstance here, as well as the fact that if husband knew that there was a Navy Federal, one would argue that he should have also disclosed that he knew that there was this additional debt that was out there on his affidavit.
And you're at your time.
Thank you very much.
Thank you both for your arguments this morning. The case will be submitted. We'll get out a timely written decision. Hope you both have a great day.
Thank you, Your Honor.
All right, next case is State versus Johnson. Mr. Presley, how much time for rebuttal would you like?
3 minutes.
3 minutes, okay. You may proceed when you're ready.
May it please the court, opposing counsel, as Joshua Krause, I've been retained by Mr. Johnson for the purposes of this appeal. I've done quite a few appeals, probably 50 appeals in 4 different jurisdictions. Usually, I'll have one strong issue, and the remainder of my issues will be things that I just throw up there because something might work, and you go with what you have, and sometimes it's one strong argument, 2 or 3 weaker arguments. Candidly, the insufficiency of evidence usually is one of the weaker arguments because it is a high hurdle for us to overcome that. In this circumstance, I genuinely believe that all 3 of these issues are equally strong. Regarding the insufficiency of the evidence, fundamentally what happened is the state alleges that Mr. Johnson lived in the apartment, therefore he's responsible for the trafficking that they believe occurred there. And it's not simple math of ownership or control of the premises plus whatever is found in there does not mean you control it. The case law is clear, the definition of possession is clear on that. That ownership or control of the premises where it's found is insufficient. And in the one case that I cited, you have a passenger who's mere inches away from drugs. The drugs are found in the seat back in front of him, and the court had indicated that was insufficient.
But there was pretty compelling evidence that this was his place, or he was at least staying there. So it's not like he's an overnight guest and just suddenly. There's a bunch of evidence about his connection to this location.
They had him under surveillance for months, very tight surveillance for weeks prior to this. Nobody observed him in the apartment. They also had officers stationed outside of that doorway, specifically looking to see if he was going to enter or leave the premises. They didn't see him.
Let me ask you this then. Well, if it's not his apartment, does he have standing to object to the search of that apartment?
Yeah, I think the motion to suppress issue is an interesting one. I remember reading the arguments that were presented to the court.
That was presented?
Yes. And I think it cuts both ways, because if the state's arguing he doesn't have standing, but then on the other end, the state's arguing that it was his apartment. So it does, those are both separate fact issues. One is the argument presented by Mr. Haas for the motion to suppress was that they didn't have sufficient evidence to a nexus to say that it was his apartment. That doesn't mean it's not his apartment. That means from a legal perspective, judge looking at the affidavit, is there sufficient basis in there to link Mr. Johnson to that apartment? And that's one issue.
Do you mean the nexus between the apartment and the drug dealing?
Well, there's that nexus as well, but in terms of linking him to the apartment. So Mr. Haas was simply pointing out that the affidavit itself was insufficient to link Mr. Johnson to be living there. And that's a separate issue than whether Mr. Johnson was living there.
I thought there was a utility bill in his name.
So the officer said that he saw it, and he didn't take a screenshot, but he saw that there were utility bills, a utility bill linked to to that residence, to his name. But then the officer also testified that they found an internet bill, and I'm not sure if that was the same, if that's considered a utility or not. The only evidence presented to the jury was I think it was a Comcast, or it was some type of an internet bill that was in his name.
Okay.
However, this was a two-layered approach here. First, is there sufficient basis to prove that he was living there when nobody ever saw him in that apartment? And
Now
he's
you're
under-
talking, this is a 4-family, right? A 4-family building?
I'm not sure how many units there were.
Okay. And they saw him, did they see him coming out of the front door?
It was unclear. I tried to specifically, if you look in the facts section, I tried to specifically link to where they described that. It was a little bit confusing, but it seemed like they thought maybe he was coming from a parking area or something, but it wasn't through the main entrance to the apartment buildings. He was coming out of somewhere else. And he's been under surveillance for weeks, and they never saw him in that apartment. Nobody testified to the jury that they saw him in that apartment.
In the apartment, but they
Right.
saw him coming from the building.
Right. And there was...
And then there's wasn't there a neighbor that said that he lived there?
That's an important distinction. That neighbor testified, or it wasn't, the words of that neighbor, or what the neighbor told the officer, that was actually part of the motion to suppress, not at the trial. You'll see that the state references that in the argument regarding proving that he lived there, but there's no factual citation to that at that section. And you'll see later on in the motion to suppress, the state of Ohio did have a factual citation where the neighbor referenced it. And it was on page 54. It was very early on. It was in the motion to suppress stage. So there was not testimony at trial that the neighbor said he lived there.
Was the neighbor piece of that in the affidavit to the search warrant?
Yes.
Okay.
Yes.
Okay.
That was used for the motion to suppress for the search warrant. That was not presented to the jury. But this second layer is very crucial. The second layer is, let's assume arguendo, he lives there. Let's say we see him coming and going from that apartment in and out of it 50 times. Let's say the lease is in his name and all of that's presented to the jury, which it wasn't here. But let's assume uncontroverted evidence that he lived there. The second step is owning the premises or living there. That's an insufficient basis to say that he possessed or controlled everything in that apartment. And there was a vacant bedroom. You got to also remember that there was a bag from someone who just got out of jail, who was a known drug trafficker, who was in that apartment.
The bedroom didn't have a bed in it? The
One
second
did not. That's
Okay.
correct. But you have the jail bag of someone who just got out of jail for trafficking. Or that was a known trafficker who just got out of jail. And that's how the officer had described it.
Let me ask you, you're talking about the surveillance of him.
Yes.
And as I read the affidavit, it does document 2 drug transactions involving your client. But what I don't see in there, and I'm just wondering if there was any other testimony about this, was any connection between those drug transactions and the residence.
Correct, and that's the other nexus that Judge Winkler was referring to prior.
Yeah.
I did not see anything regarding that. And the dates for those, when he was under surveillance, and these dates are important because the state references Lang, and I thought Lang looks very convincing. Judge Winkler, I believe you were the author of that opinion. The way the state presented it, it looks very compelling that this could be similar to Lang. But these dates are important, and that nexus as well is important because it's time and place. January 24th, mid-February, and then March 2nd. So you've got not even a specific date in February, but let's say second week of February. And then we have a few week gap, and there's no GPS surveillance on him, or at least not that I saw referenced in the affidavit. And if we look at Lang, the dates on Lang were July 29th, August 25th. 2 days later, they got the warrant on August 27th. And in Lang, they observed him daily going to and from. They had a GPS unit that had been installed in his vehicle confirming exact times that he went. They did 2 controlled buys, and then he would return to the place. So you have daily transactional records of him going to and from that place with a GPS monitor, and they waited 2 days to get the warrant. That is much closer in time, is much more proximate than this case where they waited weeks to go to a residence where they had a utility bill where they knew it was being shipped to him, and a neighbor said he lived there. So there is not a time and place nexus to Mr. Johnson in terms of the warrant.
Let me ask you this, though. My understanding, there were 3 controlled buys observed by the police officers.
There's 2.
Just 2, okay, downtown. And in one of those buys, I think it was a blue Kia or Hyundai, that your client was in. Police officer eyeballed him, saw the transaction, then saw that same car parked at the apartment. Are you saying that's not a sufficient nexus with drug dealing happening downtown and then seeing the exact same car parked at your client's apartment?
I don't think it adds anything to it. Otherwise, we're saying that every time you can always search a residence if you see someone doing drug deals, because that person drives their car and they go to their house. And
So
I do understand.
we would just assume that anybody that deals drugs keeps the drugs in their house.
I don't think that's a fair assumption. Some of the case law says that it's possible to make the inference, but again, it has to be close in time and the location and linking it to the drug dealing. And in Lang, this court was very clear, highlighting that they knew every day exactly what he was doing. They knew where he was going, and it was monitored for weeks. And in this case, they tried to survey him, they tried to use surveillance, and they couldn't pinpoint him at the apartment.
Well, let me ask you this. I think in the affidavit, they were using some sort of surveillance that put him within 250 yards of that apartment for long periods during the day and during the night. That was in the search warrant affidavit.
Yes, not presented to the jury, but yes,
Okay.
for the search warrant. They did do cell phone pings, which then, at most, would indicate that even if it indicated that he lived there, that alone is not enough. Because in the case law, it would just say, anytime you know someone's a drug dealer, you're just automatically allowed to search their home as well. And that's not it. You have to have, it has to be particular as to the place that you're searching. Not the person, not just we think this person did something bad, so we could search everything connected to him. I also wanted to bring up the evidence was as strong or stronger possibly against other people that weren't even charged. The female was seen leaving the same place as him. The firearm was tested. DNA profile was obtained. It wasn't a full DNA profile, but was sufficient to determine that it was a female. They found no DNA gun and no male DNA on the gun.
Were the drugs in the firearm found out in the open, or were they hidden somewhere?
It wasn't clear the way it was presented through the testimony. I believe, I would ask court to check back to the citation. The state alleges that it was found in a dresser, the gun. I believe the drugs were not
The
found.
dresser in the bedroom where there was the only bed.
That's what the state's alleging.
Okay.
And that gun, though, does not have his DNA on it, doesn't even have male DNA on it. It has a female DNA, which would indicate that a female was the last one to touch that firearm. So it's not even that there's a lack of evidence, there's evidence that somebody else possessed or controlled it. And I also don't want to ignore the other issue in terms of turning over the notes. I was reviewing...
Yeah, what is, if you're right on that, and the judge should have at a minimum allowed those notes to be in the record, like what's the remedy?
Well, the remedy would be this court would be able to review what those notes contained and determine if it was...
No, I understand. I
That's-
understand. I'm saying, what would the remedy be that you would ask us to impose?
In this case, it would have to be a mistrial. We can't go back in time and give a corrective instruction to the jury or let Mr. Haas see what was in those notes. And we know they related to his testimony because he literally was reading them and looking at them to answer questions. The state kind of used that to indicate that Mr. Haas then knew what was in the notes, so there was no issue. No, Mr. Haas was saying, I know they're related to his testimony. I know exactly that it's related because he's reading from it. And there's no discretion. I'm looking at, this is the Ohio Evidence Courtroom Manual. In the notes, this was Mr. Haas had actually attached this to his motion at the court. It says, accordingly, documents used at trial to refresh recollection must be delivered to adverse counsel on request. Must. In this context, Rule 612 does not provide for discretion. The discretion would apply to documents used prior to trial. So that would be if he said the night before he reviewed some notes and then he went in and testified and you asked for those notes, you have discretion there. There is no discretion here by the judge. The court must provide them to adverse or opposing counsel. The court must preserve.
Well, the court can review them in camera first and decide some are not appropriate, right?
The portions that are not related to the testimony.
Right.
Again, they don't have to be relevant, they have to be related to the testimony. And we know they were here, and you excise the portions that are not related and you provide it to counsel. But you can't tie his hands behind his back and tell him to conduct a trial without everything he's entitled to. I don't think this is, that's why I didn't want to gloss this over. I don't believe this is, I think I'm over on time.
You are over on time.
This is not a minor issue. As trial counsel, this is one of the few opportunities where the state must provide something to us during trial of this nature. Most things are discretionary in terms of what evidence is admitted or is not. This is not just grounds for mistrial. This is a mistrial. There is no discretion whatsoever in the court. Really, I'm shocked that when the rule indicates you must preserve.
And if you want to reserve time, I think you're...
Thank you, Your Honor.
Yes, thank you. Ms. Lott? And could we start with that last point that he ended on in terms of the notes? Because the rule is pretty clear that the court must make those part of the record so that we can review them, and that didn't happen here.
But the very first sentence of the rule says that the court, in its discretion, must determine if it is necessary in the interests of justice to have the writing produced. And the judge, right at that point, said it is not. If you go to page 378 of the transcript.
Right, but I want to focus you. This says any portion withheld. So the judge gets to make the call. Then it says any portion withheld over objection shall be preserved and made available to the appellate court in the event of the appeal.
I feel like he didn't even get beyond the first sentence, because exactly what defense counsel was arguing about, if you look at page 378 of the transcript, he vehemently argued that he did not want that in, that it was not allowed in. And then he did an about face during trial and tried to argue 612.
Well, but there's a difference between letting it in and being able to inspect it for purposes of potential impeachment.
But I don't even think he was trying to impeach him with it.
Well, but he didn't know what was in it.
But he said he did. There's a point where he says he knew exactly what was in it because he knew, and he talked about how the police officer had testified.
Mm-hmm.
And in this argument on 378, I mean, if you look at it, the attorney showed that he knew everything in it because he said, based on what...
And in 378, was the officer testifying at that point?
Yes, this was the beginning of Detective Hunter's testimony. And the defense attorney, stopped and said, I don't want any of this in. I know what this is. I think this is highly prejudicial. I mean, he was vehement about it. So I think it was very disingenuous later to say, oh, under 612, I should at least be able to cross-examine with this.
So under these specific circumstances, because the attorney tried to keep certain information out previously and indicated he knew what was in the writing, you're saying we don't need the writing to be in the record in order to determine whether the judge abused her discretion in this case?
Yes.
Okay. Because normally, if you're cross-examining a police officer and you're looking down at notes, you don't know what they say. And if we didn't have that prior exchange earlier,
true.
And then in that situation, the judge would inspect, the judge would make the determination, and then the notes would then go into the record for appeal, right? Because the appellate, how are we supposed to know? But you're just saying under these specific circumstances, based on this prior exchange, that's how we know the judge did not abuse her discretion.
And the judge did look at it.
Well, she looked at it, but we don't know what it says.
True.
We just have to go by the defense lawyer previously saying that he knew what it said.
Yes, and I think he was so vehement about it, and the discussion was so certain in what he was saying, that in this circumstance, I don't think he even got past the first line when the judge said, excuse me, I don't find it's in the interest of justice.
Right, but this is where I keep coming back to. Like, the court's perfectly capable of making that determination, and maybe the court was absolutely correct there. But the whole reason we have this subsequent provision is to make sure that we get to inspect it and evaluate whether the court was right. So if the court says it's not in the interest of justice, like, that's all well and good, but how are we supposed to evaluate that if we don't have the notes?
Well, the court did base it on what the defense attorney had said. And she referenced back to that.
Mm-hmm.
And said that you yourself kept saying, this should never come into the record. And I think she was justified in her actions there.
Talk to us about Nexus with the search warrant.
Yes.
Affidavit.
This search warrant very closely tracked Lang, except that Lang, the facts in Lang, they did say, they didn't tell how many days, but in the opinion it says, we tracked him day after day. This is Lang.
But wasn't Lang, he was driving from the apartment to a drug deal?
Yes.
And back. And we don't have that here.
We do have that.
Let me stop you, Ms. Lapp, I'm sorry. The judge found that you had that, but it was not contained in the affidavit. There was testimony that they tracked the defendant from the apartment to the sale, but it's not in the affidavit.
Well, the affidavit shows there's first the sale in January. And
what I'm trying to say is there's nothing in there saying that we saw him drive from Allendale, whatever the apartment was, downtown, make a deal, drive back home, drive from Allendale, go back down, sell the dope, and then go back home. That's not in the affidavit. I can tell you because I looked.
But the affidavit does say that he was, that specific car was seen parked outside the residence. The police officers are conducting surveillance. They have the cell pings that show the defendant was there, extended hours of the day and night. Then they see him come out to the common courtyard and leave in the same Elantra.
Right, but where's, like, they're doing all this investigation and they're using the cell phone records and all of that, but back to Judge Winkler's point and Lane, like, where is the evidence in the affidavit that he was going physically from the house to the drug deal and back? Because that is what we were focused on with Lang, that said, well, that's probative that there's probably drugs at the house. But here there's two transactions and there's no documentation of the back and forth from the residence to the transaction.
I think you have it. It's not as much as Lang. But they said he was at the apartment, drove away, and then the police officers were watching the controlled buys. And the Elantra was at the second controlled buy.
So you're saying the affidavit says that immediately preceding the controlled buy, he was at his apartment? That's in the affidavit?
On or about the week of February 21st, they have the cell phone pings that show that he was at that address for extended hours of the day and night.
That establishes like that he lived there, I guess.
Yes.
That's arguably.
Well, then while performing undercover surveillance, we observed it parked outside the residence. Then he left in the car. Then the week of February 28th, they witnessed him exit the rear of the building, get in the same car, and drive off. If you mean that
But I mean, like, he could have been going to Kroger. Like, we don't, like, where is he going?
But with the timing of the CIs saying that is the time that I met him and the police are with me and directing me to go perform these sales, that was lined up with when he was seen leaving.
You would agree
Okay.
that the law says that just because somebody is a known drug dealer, we cannot assume that they have drugs in their house, right? Just to get a search warrant.
But you've got,
I'm not asking about this. I'm just saying, we can't just make that assumption that if somebody's a known drug dealer, then we get to search their house because we can.
not simply because they're a
Okay.
drug dealer.
There has to be a certain nexus.
Yes, and that's what the judge found here.
Okay.
Because you did have him coming and going from that address. You have the CIs saying that they went and conducted these sales. And he's in the Elantra at least 3 times. One drug transaction, he was in the Elantra. And then the Elantra comes back to that same apartment. The police set up these sales. Another CI goes out and conducts a sale. They're watching the apartment, and the Elantra comes back and parks there.
Right after the sale.
With the,
I don't recall that amount.
yeah, not at the exact, it's this, the affidavit talks about, this is what we saw during the week of the 21st. Here's what we saw 7 days later, until on the week of the 28th. And then within days, they confirm more and more about the fact that he lives there, and they sign the search warrant March 2nd.
So talk to us about counsel's argument that the 2 controlled buys were too remote from the signing of the search warrant on March 2nd.
I think everything that happened with the first buy was 1 month previously, but the second buy and then more of the surveillance all occurred from February, the week of the 21st to March 2nd. I don't think that's too remote. They were very specific about what the officers were about the surveillance and what they were watching.
Was the second controlled buy on February 21st? Is that the correct date?
It says on or about the week of February 21st in the affidavit.
Okay. All right, so we don't, all right.
If you're saying, does it say that on this date, when we saw the car, was it directly after the sale? The affidavit doesn't give those times, but it does say, then the car is seen again at this address. Then the car leaves this address. We have, the cell phone that he was within 200 yards of this address, day and night. And I think that is sufficient, especially, looking at the cases that say if there's a nexus, direct evidence of drug activity at the dealer's residence is not needed to support the search warrant. And I think this, not as specifically as Lang, but I think the facts on this case meet that standard. And there was, in a reply brief, counsel noted that I didn't cite Gales and talk about it. But in Gales, the CI was not under surveillance during the buys, which we did have. We had officers watching and monitoring the sales. Gales said there was nothing that tied his car to the residence. Police did not observe the controlled buys, and the affidavit was written 3 months after what the police had seen, and I just don't think that applies to the facts of this case.
Okay, thank you. Mr. Crosby, you have 3 minutes.
Maybe 3 minutes, but
We were asking you questions, it's okay.
I'll try to be very brief. It's important to note that on that Rule 612, there was discussion about whether the court abused its discretion. I firmly believe that it was not within, the court didn't have discretion.
What about Ms. Lepp's argument that trial counsel absolutely knew what was in that document?
It's important to read that back and forth with him and the judge. Mr. Haas is saying he wants to see those notes, and she makes a comment. It's kind of an interesting back and forth to read in its entirety, actually. It's about a page and a half. But he says, the judge says, how do you know that those notes are relevant? This is before the judge had looked at them. She said, how do you know those notes were relevant? And he says, I know because I know exactly what he's doing. I know exactly what's in those notes because he's reading from them. He wasn't saying, I've seen those notes on a prior occasion. He didn't say, I filed a motion in limine on those notes. His motion in limine said he didn't want the jury to hear about prior drug transactions that weren't being presented for this case. That was his motion in limine. That doesn't mean his hands are tied. That doesn't mean he's not allowed to cross-examine the witness like anyone else. And the rule is very clear. The commentary of 612 is very clear. The purpose is to cross-examine the witness. You are allowed then to admit portions of it into evidence if they are relevant and otherwise admissible. But that's way down the road. The initial analysis is simply, if they used it while testifying, you're allowed to review it. The interest of justice portion, if you look at this, at Rule 612, the first sentence has a colon. So it says you can, if they use it for testifying, either one, while testifying. That's what was happening here. Or two, before testifying, comma, if the court in its discretion determines it is necessary in the interest of justice, comma, an adverse party is entitled to inspect it. So there's the two prongs there, the two portions of that. One has no discretion. If they use it while testifying, you have to turn it over. And I did look at, again, that practical application of Rule 612. This is in the Ohio Evidence Courtroom Manual that was submitted with the motion. It says, in this the documents used at trial to refresh must be delivered. Does not provide, Rule 612 does not provide for discretion. There is no discretion when the witness uses it at trial.
So is there any evidence in the record that trial counsel actually physically had, defense trial counsel actually physically had a copy of these notes?
No, he absolutely did not. There's no evidence that he did. The back and forth with the judge was him trying to explain why he wanted to see them. She indicated, you don't even know what's in them. Meaning, why do you know that it's important for you to see them? You don't know what's in there. He doesn't have to prove to her that it's important, or he doesn't have to prove to the court that it's important. He has an absolute right to inspect those
He
notes.
specifically asked the witness if he was looking at his notes in order to answer the questions?
Yes. And the witness even asked to see his notes to answer a question. He said, may I get my calendar, which was in his packet of notes. Then Mr. Haas responds, I see you have a packet with you. Are you using that to help you testify? Or do you use it in preparing to testify? And he said, yes. So he prepared for it prior, and he physically used it and actually asked, may I reference my notes to answer a question?
Great. Thank you. Thank you both for your arguments today. The case will be submitted. We'll get out a timely written decision and hope everybody has a great day.